Good afternoon. Welcome to the next in our series of webinars on the Solicitors Qualifying Examination. Today we're here to talk about SQE2, which is the second part of the assessment in the SQE. A reminder that SQE1 primarily is the assessment that covers functioning legal knowledge. There's still a debate about whether there's some element of skills in there, but actually in terms of testing people's skills, that is going to be done in SQE2. So it's looking at things like writing, client interviewing, research. And today we're going to be covering in our webinar a bit about SQE2, but in particular focusing on one big area where we're still to make a final decision as to our approach, and we really want to understand people's views. So those who joined me the other day from webinar might recognise that I again find myself in my toddler's bedroom. It's the place with the best Wi-Fi, but it's also the place where there's the most doors between a 2- and 4-year-old. But there is a slight risk that my children may come in and share their views on the SQE, so apologies if that happens. Julie, I think, has older, tamer children, so hopefully that risk is reduced. And also Julie will be the professional side of this webinar, because whereas I have a cot and a Dr. Seuss picture behind me, Julie has, I'm sure, very learned books behind her. So those of you hopefully who have been following the SQE will know Julie Brannan. She's our Director of Education and Training, and as we say, we're going to run through this webinar, but we really want to get feedback after it, and we'll be explaining at the end of the webinar how we do that. So over to you, Julie. Before we go into detail of the issues we want to discuss, people may remember we ran a pilot exercise to test the SQE1, and we published the results of that. And we've at the end of last year, we ran a pilot exercise on SQE2. How's that gone, and when will people hear information about that?
Yeah, no, that's quite right. We ran the SQE2 pilot in December, and since then we've been marking the results and analysing the data that it created. Went very well. First of all, what we needed it to do was just to test operational processes, and that all ran very smoothly. It ran across the written skills element of it ran across 29 Pearson View centres and 2 centres for the oral skills assessment. I think I've said previously we had 167 candidates who participated in that, and that gave us pilot data of value, but that we also need to put in the context of wider experience and expert views. And you can see there we've got a number of experts who are helping advisors on all of this. We also have data from the QLTS as well. So we've got quite a lot of evidence that can help build up a picture for us and shape the decisions that we need to take. As ever, particularly when you break up your data into very small groups, you can sometimes end up with very, very small numbers of candidates, and therefore you do need to take care in analysing small data sets from subgroups of participants.
Yeah, I suppose no pilot is ever going to perfectly replicate what a real life assessment would be, both in terms of the motivations of the individual taking it, but also the potential numbers of people who are going to be taking it.
Well, that's absolutely right. And it doesn't mean to say that you shouldn't go ahead and do the pilot, because pilots are helpful and do test processes and do give you insights into things. But pilot candidates are not going to be the same as absolutely the same as the people who take the ultimate assessment. So in this case, for example, the candidates had not necessarily all passed SQE1. They were a different group, whereas in the real live assessment, candidates who've progressed to SQE2 would have passed SQE1. And of course, they're not going to be as motivated as if this was really the real live exam through which they were going to, they hope, qualify as a solicitor.
Even though I think there was perhaps money on offer, it's not quite the same. So moving on to the pilot, that's obviously to test the sort of robustness of the assessment. Is it consistent? Is it meeting the right standards? But there was one particular issue where I suggested at the start where we're still thinking about where we should go. Do you want to explain a bit more about that? It sort of comes down to whether students or candidates should have choice or not. Is that right?
That's right. So, as you said in the start, Ben, SQE2 is an assessment of candidates' legal skills. But in order to test legal skills, you need a legal practice area as the vehicle through which you test those skills. You can't test those skills in a vacuum. So we wanted to explore really how we assess those skills and whether we assess them in the same context for all candidates, or whether we give candidates an element of choice so they could choose the practice areas through which they would have their legal skills assessed, perhaps to reflect prior work experience or future career aspiration. Oh, Ben, I seem to have lost you.
Sorry, just a reminder for everyone, I was on mute because there was screaming going on in the background, which no one needs to hear. Not my screaming, I hasten to add. So the SQE2 skills assessment, that's been actually developed over several years now. Do you want to remind us exactly what it covers?
Yeah, so I hope you can see on slide 4 the list of skills. These are skills, and they were divided for the purpose of the pilot into what we call 7 stations or 7 tasks that people undertook. And I said on a number of occasions that what's good about those skills is that there's been a large measure of consensus around those skills, that they are the right skills that solicitors do need to have in practice, and that we need to test before somebody is admitted as a solicitor. As I said earlier, we need to assess those skills through a legal context, and on the right-hand column in the slide, you can see the 5 contexts that we propose assessing skills through. They represent the reserved activities, so the areas of practice that we license solicitors to practice in, and that other members of the other citizens, other individuals who are not solicitors and not licensed cannot practice in. So property, probate, civil litigation, criminal litigation are all reserved activities. Business isn't, but it's clearly a very, very broad, important and widely practiced area, and for that reason we've included it as one of the contexts. So those are the list of skills and the list of contexts. And sorry, Ben.
So I was going to say, let's move on to the, I suppose, the pilot itself. The original assessment specification, we tested a bit of a different approach actually in the pilot we set out in terms of our approach to those contexts. Do you want to just talk a bit through that and why we did that?
So just moving on to slide 5, when we originally went out to consult on SQE2, we spent quite a lot of time talking to people about the way that current, if you like, custom and practice has developed in our profession. What happens at the moment is that people tend to begin to specialise before they've been admitted as a solicitor when they choose which firm to train in. So you might choose a commercial firm, in which case it's unlikely you will be doing any criminal litigation or probate, for example. Or you might choose a small high street firm where you may not be doing so much business law. So when we talk to people, people recognise that was a pattern of practice, and they thought that it would be appropriate to give people the opportunity to have their skills assessed in some of those practice areas, but they didn't see the need to assess them in all, given that we had assessed people's knowledge of all the reserved activities extensively through SQE1. We originally consulted actually on suggesting that people should be assessed in 3 practice areas or contexts, but actually following feedback from stakeholders, we reduced that to 2. We didn't think it was appropriate for it just to be assessed in a single context, because we were worried about case specificity and people being able to practice in one area but not necessarily being able to transfer those skills into other contexts. So our compromise, if you like, was to suggest people should be assessed in 2 contexts which they could choose. Back in 2018, as stakeholders will all know, we brought in Kaplan as our assessment provider, and they raised concerns with us about really whether, if we had that choice, we would be able satisfactorily to assure ourselves and consumers and the profession that people who had been assessed through different choices had all been assessed to the same consistent standard. And as you all know, having the idea of SQE as being a consistent assessment, fair to everybody, where everybody takes the same assessment, is at the heart really of our proposals. So the question for us was that we wanted to explore through the pilot was, could we have an element of candidate choice which still gave us sufficient confidence that although people were taking different assessments in different practice areas, they were all being assessed at the same standard.
And just to be clear then, in the pilot itself, were people able to choose any of those 5 specialisms, or what was the approach there for the pilot?
For the purpose of the pilot only, and given that we knew we would have limited numbers, we gave candidates an option of 2 choices, either business law or criminal litigation. So candidates came along and they were assessed in the 7 stations through a common core, so where they took all the skills assessed, sampled across all the practice areas through a common core that both cohorts of students took. And in addition, they took the 7 stations either in business law or in criminal litigation.
Okay. So they had an element of choice, so to speak. Yeah. So sort of a mix and match. So I think it'd be probably helpful to people, because actually this is what we want to get people's views on. If we sort of talk through a bit more detail in the 3 options and what I suppose the pros and cons of each of those options are. So if we start with the original option for the original design, and that's the one where you get to choose. Can you tell us what sort of the approach, what the benefits of that, why we took that approach originally, giving people choice, and yeah, some of the benefits, and then perhaps could move on to some of the downsides?
Yeah, so just before we go through this, I think as you will have seen on slide 6, there are 3 options that the design of the SQE2 pilot enabled us to explore. And as Ben said, the first one was specialisms only, where candidates took legal skills assessments in 2 contexts of their choice. The second was a uniform exam, where candidates would take the same exam sampled across all skills and contexts. And finally, the common core. Now, because the pilot was closest to the common core, where they had a common core of assessments which everybody took, but then they also took specialisms, that did give us some insight and enable us to explore the three options.
It's a mix, effectively, of the two extremes, so to speak.
That's right.
Yeah.
The common core was a mix of all of those 3 elements, had elements of everything in there. So it enabled us just to get some insight of what would happen if we went down any of those 3 routes. Okay, so moving on then to option 1. This is the specialisms model that Ben identified, the one that we originally consulted on, where people just choose at their choice the legal context in which they have their skills assessed. And before we go through these slides in details, I think it's probably fair to say that all of these options have their pros and their cons. There is not one which stands out as the obvious choice that everybody should plump for. If that was the case, it would be an easy decision. There are pros and cons for all of these, and what we need to do is to evaluate those pros and cons in coming to a decision about how best to move forward.
And I suppose it's worth saying we've been speaking to people for quite a long time about this, haven't we? But we still want to get more feedback, which is what today's about. So yeah, sorry to interrupt you there, Julie. Yeah,
that's right. Many of you who are listening to this webinar will be very familiar with this issue, because we have been out, we've talked to the profession, we've talked to training providers about this already. But what we've now got is greater insight, I think, into some of the challenges through the insight that we're beginning to see come through from our analysis of the pilot. So in terms of SQE2 for option 1, the pure specialisms, I think the first thing to say is that we do already have in place processes that help us assure the quality and consistency of assessor judgment. So obviously at the heart of any assessment are the professional judgments of your assessors, inescapable, and regardless of whatever model you go down, you will have those the need for those professional judgments. And we've got mechanisms in place, so we know what the standard is that people would be assessing against, and that would be the same standard for all options. There would be common assessment criteria, again, for all options. We've got online tools. We've got a little tool called Crucible, which enables assessors' judgments to be monitored in real time, so that they can be moderated. You can intervene if somebody looks as though they're marking too harshly or too leniently. You can step in and adjust as you're going through. So we've got quite sophisticated mechanisms to ensure that assessors' decisions are monitored, reviewed, moderated, and to try and make them as consistent as possible. But it is making them as consistent as possible. We would not have absolute assurance because people wouldn't be taking the same assessment, and we wouldn't have on this model any statistical evidence to correlate performance in one option against another option to enable us to be absolutely sure that those judgments were consistent. This option clearly gives the best fit with qualifying work experience for the reasons I set out a moment ago. Most people will not get qualifying work experience across all the reserved activities, and this enables them to concentrate their qualifying work experience in the areas on which they're going to be assessed, and to help develop the skills in those areas. And it's the least market disruption, therefore, and in line with existing customer practice. So those are really the core benefits of this option. But there are disadvantages, and the first I've already talked about. It's looking as if it will be a challenge to get any statistical evidence to demonstrate that the candidates are being assessed fairly and consistently, even though they're taking different assessments.
Yeah.
And that is a challenge to our starting point for the SQE, which was to deliver consistent, high quality assessments. You know, there is that element of choice, and therefore there is a question mark about the consistency of those judgments and pass rates. We also tried to look through the pilot at whether you could infer that because a candidate was competent when they had their skills assessed in one practice area, that was transferable to a different practice area. It's a hard piece of analysis to do, and I'm not sure that we've got any absolutely conclusive evidence from that, but I think we've probably got some indicative evidence that skills may not be transferable, or at least not wholly transferable. And I think that probably resonates certainly with me, and I'd be interested in your views in terms of experience of how candidates move or trainees move around their traditional training contract. So people will be familiar with the phenomenon that a day one trainee starts, they develop their skills in their first 6 months of training and get to a reasonable level, they move seat and their skills drop down when they start the next seat. But they probably don't drop down to where they were right at the beginning of their first seat, but they do drop down, and then they continue to grow their skills through their second seat. They move to their first seat, third seat, and again skills drop down. You have the same phenomenon, the same pattern. Now, people will tend to see over that time the skills generically improving. People often say they prefer to have a third or fourth seater trainee than a first or second seater because they will generally be more experienced and their skills will be more developed. But there still is that phenomenon of people needing to develop their skills as they move around training. So that probably resonates with that. And that creates challenges, of course, because it raises challenges about how to develop your skills so that they're ready for assessment through a uniform model, if that's where we end up. But it also raises challenges in terms of this particular model of assessment with optionality, because it doesn't seem to be well aligned with the reserved activities and the licensed practice. So the critical thing there is that we have one license to practice. It's a broad license to practice. It covers a wide range of areas, and there is at least some suggestion that just because a candidate is competent to practice in one context, that doesn't mean to say that they're safe to be a solicitor across all that range of reserved activities, and that is clearly a regulatory issue.
And it's a tough one, isn't it? Because the reality is, I think most people do specialise, don't they, after they've qualified, and some people may never ever touch loads of areas of law. But I suppose the thing is, if you give someone the title solicitor, that does give them the licence to touch all those areas of laws, including the reserved activities. So that from a public protection point of view, there's a potential tension there, isn't there, for a regulator?
I think that's right, and I think it's quite a curiosity, because it's absolutely right. This is custom and practice. We're all so used to it. We're used to the idea that people will begin to specialise before they are admitted, yet they may well not be safe to practice across all specialisms. So it's something we are very familiar with, but somebody looking at us from outside the profession, would probably be surprised about that. And probably if you were starting with a blank sheet of paper, you might not necessarily start there. Moving on, I think, are you worried a bit about time?
No, I'm smiling because I've got a 2-year-old on next to me, which if you want to see him, there he is, but we'll try and get them out now. So let's crack on.
Okay, so cracking on. So just another couple of points there before we move on to the second option. We also have looked quite carefully about advocacy and negotiation, and whether there is a particular association, if you like, of those skills with particular practice areas. Advocacy, I guess, is pretty obvious. The reserved activity there is rights of audience, and so it does fit properly with criminal litigation and civil litigation. So that creates a challenge if we're giving people the right to choose not to be assessed in those particular areas. Negotiation was interesting because that's not something which has previously been assessed on the LPC, and it's not currently assessed on the QLTS. So that was a new skills assessment, and we wanted to assess it through the case and matter analysis. What we gleaned from the pilot on that is that it fits probably better in some practice areas than others. So it fits very nicely in civil litigation, in property and in business, but it doesn't fit well in crime or in probate. And I did have a very useful conversation with colleagues from the CPS, which was very helpful, who confirmed to me that actually, yes, they would not expect significant negotiation to happen in the context of a criminal prosecution. So again, that raises some challenges in terms of assessment design if we go down a pure optionality route. And final point there is that of course, what we're saying in this is that people would take different assessments and different combinations of assessments, and actually we had 5 cohorts and different combinations of those, 5 contexts and different combinations of those contexts. It would be 10 different possible assessment combinations that people could take. And you may well have different pass marks in those assessments, reflecting, ensuring that the standard was, as far as we could, make it consistent, but nevertheless different pass marks, and certainly you might well have different pass rates. That might not mean that the assessments were wrong, but it would mean that you might well have different pass rates in different contexts. And the challenge for us would be to demonstrate that, notwithstanding different pass marks, different pass rates, the standard was a fair and consistent one across the choices.
And obviously a key part of sort of our role and the importance of any professional qualification process is that the public being able to trust that solicitors have met a consistent standard, law firms who want to employ these people being able to trust they met a consistent standard, and that's one of the primary reasons we're introducing the SQE. But yeah, there is a risk that it slightly chips away at that trust, which if we move on to option 2 in terms of the sort of common core plus specialism, that issue still exists for option 2, doesn't it?
Yeah, so option 2 mitigates some of the challenges. So what it gives us is that we have some assurance that candidates have had their skills sampled across the full range of competences, of practice areas, I beg your pardon. So they would have been assessed and had their skills sampled through those practice areas. And it gives you the additional advantage that candidates may take some reassurance from the fact that their assessment would be weighted towards an area perhaps where they have practice experience, or perhaps which is important to them because they intend to practice in that area. So it reflects their personal circumstances a little bit. There's some tailoring to the individual circumstances of candidates. But the big challenge here was that we explored through the pilot the extent to which we could use that common core, if you like, as a yardstick or a measure against which we could measure performance on the two specialisms to make sure that they were consistent, of a consistent level of difficulty, and so that the pass marks and the pass rates equated to a consistent standard across those options. And that proved very, very difficult. What we uncovered, or what we found in the pilot, was that some people who did better in the specialism did worse in the common core, and vice versa. So there was a big sort of scatter of performance between the common core and specialisms, and you couldn't necessarily correlate performance in a specialism against performance in the common core and see that there was a pattern which enabled you to gauge and judge the comparable level of difficulty or demand of the specialisms. So that was really very, very challenging. I think that the second bullet point makes the point that although we've got some evidence that people have had their skills assessed through the reserved activities, it doesn't probably sample them enough to be reliable. You probably need somewhere in the range of sort of 14, 16, 18, that sort of number of assessments to be sure that you're to enable you to be sure that somebody can the assessment result is reliable, and you wouldn't have that purely on the common core. You would have it across the whole assessment, but not purely on the common core. Now, I've raised here the question on classroom training. A disadvantage here is that although candidates would be able to draw on their qualifying work experience, their experience of working in the office, they may well still not be able to get the range of exposure across all the practice areas. So they may wish they may need to complement their work experience with classroom-based training to extend, their skills into practice areas which they haven't got work-based experience of.
I suppose it's worth mentioning that option one's probably one of the big advantages of that is you're most likely through option one to be able to develop the skills through your qualifying work experience, and then that would mitigate or potentially remove the need for some candidates to have any extra training for SQE2, which is obviously good in terms of cost.
That's right. So the training cost for option one might be the least. The training cost for options 2 and 3 might be greater, but actually the assessment cost we think is less. So actually we think that option 2 is the most expensive option, and option 3 is probably the most cost-effective option. So the option 2 would be more expensive, certainly, and you've also, as we said before, we've got the issue around pass rates varying.
Because there's so many different options, that's going to drive up the cost of the assessment.
So many different options means lots of papers that have to be written, and also it means the timetabling of the assessments is complex as well, and that all drives up cost. So, unless there's anything you want to add on that, Julie, perhaps if we move on to option 3, and I suppose if you're an assessment purist, this potentially might be an attractive option to you because it has everyone taking exactly the same examination. So that's one of the big advantages of this option. Is that right? So obviously, if everybody's taking the same assessment, we can be sure that they have been assessed to the same consistent high standard, one of the very fundamental objectives for the SQE. So that's absolutely right. It's the best measure of consumer protection absolutely guarantees a uniform standard, and let's be clear, that's not just a uniform standard and consumer protection, that's fairness for candidates. Candidates can fairly understand that they have been assessed to the same standard. One of the concerns we worry about in terms of choice is if people were to see that there were consistently perhaps a very high pass rate for one of those contexts, they might decide to take that because that they might create a perception, fair or otherwise, that that's an easier way through. So you might get some of that sort of gaming going on. Whereas here, it's absolutely fair. Everybody takes the same assessment. Everybody is demonstrably held to the same standard. It's of course aligned with reserved activities. It ensures it means that we can have the best fit of skills and context. We can put advocacy where it best belongs. We can put negotiation where it best belongs. There is, as I said before, some assessment cost saving for candidates. And I think it's also fair to say that this is the sort of assessment that other professions have. When we look across the way that doctors are assessed, accountants are assessed, other professions assess, we see a consistent, uniform assessment, which goes with a single license to practice. So those are the advantages, but there are some clear disadvantages. It's not in line with current training practice, so it's most disruptive, if you like, of the sort of custom and practice that we have become very used to. It could restrict training opportunities, certainly practical training opportunities, because we are aware, as I said at the start of this webinar, that most employers will not offer experience across the full range of practice areas, and so that means that candidates may feel that they need to complement their office experience with classroom training, and that may increase the overall cost of qualification. And whether fair or not, and whether perception or not, it may be that people see that this exam is harder. It may be that actually some stakeholders think that that's quite right, and it shows that the SQE is a tough exam for a demanding profession, and it's quite right that it's part of the assuring high professional standards that we have been talking about. But there is certainly that perception that may be raised around that. So I think those are the pros and cons, really, Ben, of the three different options.
Yeah, and I suppose just the final thing to say, but I think you already mentioned, is that training costs might go up, although this would actually likely be the lowest cost assessment, so there may be a saving for some candidates there. Is there anything that can be done to mitigate some of the risks with a uniform assessment?
Well, I think one of the things that we're interested in exploring and interested in hearing from you, and I think it's one of the questions, and we've got a little survey for people that we'd be really grateful if you were to fill in. But one of the things that we're interested in hearing from you is whether actually there are ways that we can help minimise the training burden, if you like. The SQE2 is intended to be an assessment of legal skills. We need that context to provide the vehicle, but we're not directly or primarily assessing legal knowledge. So is there something we can do to help communicate that better, to reassure people that what we are not expecting people to do is to memorise, the detail and the procedures and so on that any competent solicitor would look up. So we're not expecting people to carry that level of detailed knowledge in their heads. So we might, what can we say that would help communicate that better to people? Could it reassure people if we were able to provide some materials so that when people turns up, if there was an assessment that needed any specific legal procedural knowledge or detailed knowledge, we could give that to people and they would use it as part of their skills assessment. Are there ways that you could see which would minimise that burden but still mean that we would have a rigorous high quality assessment that meant that we could be sure that everybody had been assessed fairly to the same standard?
So there's a lot to chew on there. Could you just sort of summarise how can those listening to this webinar, how can they help us with our decisions in this area?
Well, we would really like to hear from you about your views on the three options. We'd like your views about, in terms of high professional standards, what you think is the right option there. What impact does it have for you on your businesses, both in terms of training and in terms of recruitment? We'd like to hear from you whether it has any cost implications in terms of training. Would you be expecting to pay SQE2 candidates once they were your employees, and if so, how does this have an implication for you? And if you are a training provider, we'd like to understand how this might, a uniform exam might impact on your the design and cost of any preparatory training, and whether what the considerations are, I guess, around an optional model or a uniform exam.
That's great. And so thank you, Julie. That's been really helpful talking through all that. In terms of how people feed back to us in terms of those questions, you can see various ways you can keep in touch with us, hopefully on the slide on the screen. But we will be sending out a survey with some of those key questions to people who've signed up for the webinar. We'll be putting that on our website. But if you want to get a copy of the survey, or you just want to drop us your views, there's an email there. You can let us know. I'd also recommend subscribing to our SQ update, where we'll be providing updates on this. I know some of you might be thinking we've touched upon a sort of bit of a flavour of some of the results of the pilot, but we will be obviously in the coming months be sharing the full results and full analysis once that analysis is complete of the SQE2 pilot. So I'm sure everyone will be interested in that, and we'll be keeping you up to date. But otherwise, I wanted to thank everyone for joining us here today. If I looked bamboozled, confused, smiling, distracted at various points, it was the invading army that was coming into my room. So there we go, the challenges of lockdown. But hopefully you found the webinar useful. We'd always like to know your views on that, so you can drop us a like or a dislike at the bottom of this video. But otherwise, I hope everyone has a great afternoon, and we look forward to hearing your views. And thank you, Julie.
Thank you, Ben, and thank you everybody for listening.